Thank you, Ken, for that summary of events, especially what happened yesterday. And we have an opportunity to get some analysis and understanding as to where we are and what we're looking at in terms of the future. I have Dr. Otiende Amollo. He is the chairman of the Office of the Ombudsman. Technically, he is the one who puts in check that there's no maladministration in public office. From what you see, your initial reaction from all that has developed to date?
Well, I think overall it is sad. It is sad for justice, it's sad for the institutions, and it's sad for this country that we have to come to this stage. I think it could have been avoidable, but it was not avoided.
Right.
Now that we are there, it means we just have to figure out how to get out of that conundrum.
Mm-hmm.
Yes.
And in terms of this being a definitive pronouncement and the issue of the age of 70 for retirement being over, is it over, or are we going to expect some more trouble and back and forth?
As a matter of law and theory, it is not over. And that is because of the 5 judges, 3 ruled in a way that makes the decision of the Court of Appeal final, that it should be 70. 2 ruled that it is open to question. But overall, all of them said that because of the divisions, for now, the decision of the Court of Appeal stands until such time as there could be a bench that is not conflicted, that can actually listen to that appeal. In reality, it is not foreseeable that we could have that bench soon enough to make a different determination, at least in respect of Justice Tunoi and the Deputy Chief Justice. Yes. Perhaps on a future date, it might be so. The reason is, once the Chief Justice leaves, essentially there will only be 4 judges. Yes. 4 judges cannot constitute a bench of 5. Secondly, of the 4, 2 had expressed the decision that they are too conflicted to sit. So that would actually just leave 2. Yes. But even the 2 who are left, there were varmints and issues would be raised as to, even if we bring 3 new judges, so that in addition to Justice Ojwang and Justice Njoki, we would have a bench of 5, yes, then objection will still be raised in respect of Justice Ojwang and Justice Njoki, whether they can sit in that bench. So it's a conundrum, which for all effective purposes determines that age for now. But in theory, you could say that it could still be appealed.
Right. I'm not sure if Ken is still with us and is able to react to what we're talking about with Dr. Otiende Amollo. Ken, it seems that there might a lot to look forward to, especially tomorrow from the CJ on his last day. But it's not all over as it's been made to seem.
Yes, indeed, Mark. We'll wait for that ruling tomorrow. But my concerns from the top of this conversation, and this is directed to Dr. Otiende Amollo. Yesterday, there was a proposal by Justice Ibrahim Mohammed. He said that Parliament needs to review the Constitution and create more spaces for Supreme Court judges so that to avert such a quorum hitch. He proposed, for example, that we can amend the Constitution to have 9 judges or 11 judges. What is the possibility of this, Latari?
Well, first of all, a discussion on amendment of the Constitution is a really deep discussion. Once you go to amend the Constitution, as you know, it's an Pandora's box which once you open, you will not just go and pick that bit. You will end up with other bits. So it's not one that I would want to bring in this discussion for now. Secondly, as a matter of principle, I do not agree with the substantive argument that because there are 7 judges and they must sit 5, maybe even increase to 9, then we would be safe. The example of South Africa that he gave, there are 11 judges and there must be 8 of them. The difference is only 1. Right. You know, I think what would assist here is that 2 things. One, I have always indicated that our view was that the Supreme Court should be a court used very sparingly in very few matters. Yes. For some reason, the current Supreme Court decided to widen its jurisdiction and has accepted many more appeals than it needed to. Right. And therefore, that strains the question of capacity. Secondly, the Supreme Court needs to avoid making statements on matters that are actively in the lower courts. Yes. Because then when it comes to them, it raises issues, and that was one of the major issues that hampered this matter.
I want to just borrow from an advisory opinion that you gave in January of this year, and it was touching on judiciary and even the IEBC, and in terms of succession planning. A concern actually that was raised in this is not so much the issue of the age for retirement, but really the succession in terms of judiciary and its preparedness ahead of the general elections.
Absolutely. In January of this year, we gave an advisory opinion where we said 4 things. Unfortunately, all the 4 have come to pass because the institutions did not listen. The first issue was in respect of IEBC. And on IEBC, we raised a constitutional question in terms of their tenure, that by the time their tenure comes to an end on 14th of November next year, there's a possibility that the election petitions and process may not have come to an end. And we suggested that they retire voluntarily and they're paid their full dues. It has come to pass that now other issues have cropped in, issues of legitimacy, issues of integrity, and I think we are going exactly where we had suggested in January.
Right.
The second issue was in respect of the Judicial Service Commission Amendment Act,
yes,
where we indicated that in our humble view it was unconstitutional, and the sooner Parliament reconsidered it, the better. It came to pass that the court declared it unconstitutional just about 3 or so 1 month ago.
Right.
The third issue was in respect of succession of office of the Chief Justice. Justice Mutunga had indicated about a year ago that we'll be retiring, this Thursday, tomorrow. And so everyone knew, including the Judicial Service Commission, including the Chief Justice. I humbly suggested that rather than wait until the day he retires, let us commence the process of recruitment of a new Chief Justice. Now, I understand that the Judicial Service Commission got some advice from some other lawyers that they could not advertise the office of the Chief Justice when there's a substantive holder. Now, I don't think that is right. But for whatever reason, they chose to follow it. Now, the consequences is that now the Chief Justice is retiring tomorrow. We have the Deputy Chief Justice having been declared yesterday to be beyond the age, and therefore he will not be there. We will have no Chief Justice, no Deputy Chief Justice, and only 4 judges of the Supreme Court.
Vacuum.
And that's quite sad. The last issue we had also talked about, just the need that this idea of governance by crisis, we wait until the very last minute to do something. It's not necessary.
Right.
We indicated that because of the dangers of conflict of interest with the Supreme Court, all the parties needed to have agreed and committed before the Court of Appeal that whatever decision the Court of Appeal makes will be final, so that there's no possibility of appeal. As it turns out, it appears the parties did not agree and the court did not make them, and so they came to the Supreme Court. But the very issues of conflict of interest that I'd foreseen is what has led the court to maintain the decision of the Court of Appeal.
Let me bring in our legal affairs senior reporter, Ken Mijungu, with a last inquiry on this.
Well, Mark, I'd like to take Dr. Amollo on his third point. The Constitution did not contemplate such a scenario where the Chief Justice is retiring 1 year before his time, which is fairly legal. It did not also contemplate the scenario where the Deputy Chief Justice is supposed to retire. One other judge is retiring, and this judge has been suspended and is being investigated for misconduct. So this is something entirely new, Daktari, that was never contemplated, that at a single time or at one point, the Chief Justice would want to go away before his time. The Deputy Chief Justice will be retiring. One judge will be suspended. This was never contemplated in the Constitution. But now the question is, how do we address it at this particular point, forgetting about what you've said in your third point?
3 quick points on that. It was not contemplated in the Constitution, but it was foreseeable. By this time last year, it was foreseeable that we would be in this situation. Because by this time last year, the challenge in court by the Deputy Chief Justice and Justice Tunoi was already on, and it was possible to go either way. By this time last year, we knew Justice Mutunga will retire. So it was not so much a question of contemplation in the Constitution, it was the fact that we could foresee it. And why did we refuse to do anything about it? That's why we raised it in January. Secondly, now that we find ourselves here, in terms of the Supreme Court, what it means is that the senior-most judge in the Supreme Court will act as the presiding judge administratively for Supreme Court purposes.
Right.
And the senior most judge, as I understand it, is Justice Ibrahim. However, although he will act as the presiding judge of the Supreme Court, he cannot assume the other duties of the Chief Justice. For example, the duty of chairing the Judicial Service Commission, because the commission is independent of the court, and the commission has a substantive vice chairperson, who then will have to act as the chairperson for purpose of the Judicial Service Commission.
Right.
So administratively, we end up with three things. One, for purpose of the Supreme Court, the senior most judge will be presiding. Two, for judiciary administration generally, the chief registrar of the judiciary will continue acting, and for the Judicial Service Commission, the vice chairperson will act as the chairperson.
So there's still a way forward.
There is a way forward.
But earlier you did paint a picture of a sense of vacuum and a constitutional crisis imminent. But with what we have at the moment, moving forward, CJ leaves tomorrow, and then the vacancy of his office is gazetted, and the process starts, and they project that perhaps in October we'll have a new Chief Justice. But as is, Justice Ibrahim, you say, is the one who remains as most senior.
That is what we have to make do with now.
Okay.
But it does not mean there's not a problem. There are many problems.
Right.
One is that there are certain functions which the Constitution contemplates only the Chief Justice can do.
Right.
Now, in all that arrangement, you realize there's no acting Chief Justice, and there's no acting Deputy Chief Justice, and there can be none. So if for any reason we were to come, for example, the question of swearing in, where of any office, which the Constitution says only the Chief Justice will do, it will be a matter of debate whether the registrar can do it.
Right.
Secondly, the Supreme Court will only have 4 judges. Now, the Constitution requires that for the Supreme Court to act, it's a minimum of 5.
Right.
So we are presented with a situation where either of 3 things will happen. Either one, we will say that there can be no substantive appeal filed in the Supreme Court, until it's properly constituted, or 2, they can sit as judges, 2 judges for what we call applications.
Right.
So we will have piles of applications but no hearing for that period. Or 3, they could adopt a doctrine which the majority rejected in this case for good reason, but which they might adopt for convenience.
Right.
That is the doctrine of necessity. They rejected it in this case because those, at least 3-2, said that there was conflict of interest, so they could not adopt it. Now, they might end up invoking Section 4 of the Supreme Court Act, which says, though contrary to the Constitution in my view, that despite any vacancy in their numbers, the court can still sit. And they might say that if there's an appeal which must be had, then they can sit as 4 judges as a matter of necessity. Okay. Now, all those things is stretching legal principles. We did not need to go there, but that might be the only avenue.
We did not need to be here, but there is at least some recourse in terms of the way forward for our institutions. Thank you very much, Dr. Otiende Amollo, for your clarity and even shedding light on the place that we find ourselves as a country in the judiciary and also the IEBC, but a lot to look forward to tomorrow's